Hello, my name is James Hayden and I'm head of Lexis PSL Corporate. I'm joined today by Alistair Alcock, who is General Editor of Gore-Browne and Companies. And we'd like to talk a little bit about Gore-Browne on Companies and Alistair's time working on the product and the time as General Editor. And indeed, so as to tell us a little bit more about the book itself, its history and the future ahead. Alistair, welcome.
Thank you.
When did you first become involved with Gore-Browne and what role did you take on initially?
Well, apart from being a user, I actually first became involved in the 1990s. I had qualified as a commercial barrister, but gone into the city as an investment banker during the 70s and 80s. I then went and moved into academia and was approached particularly to revise and update the chapters that dealt with the regulation of quoted companies. And that was where I started with Gore-Browne.
Mm. And then you became General Editor further on. How did that progress there?
I became General Editor in 2003, although in fact for the previous 2 years I've been working closely with the previous General Editor, Professor Tony Boyle. And it's Tony who laid out the current arrangement of Gore-Browne and indeed supervised its transition from being a hardbound book into being a loose-leaf product. But in the period that I've been General Editor, the law in the whole area has completely changed, and the two issues that have confronted me is having to rewrite almost the whole of the contents with an enormous expansion in the amount of regulation of companies, and now moving from just a loose-leaf product over to a digital-based product, because that is the way that digital information is being transmitted across the whole legal profession. Now, the first is a ceaseless process. There seems to be no end to the changes in company law and regulation. The second is somewhere where we're in the middle of the process at the moment.
Yes. And when you started out, what aspirations did you have for the product and over time, and how has that panned out?
Well, we've got to start off with what the basic product is, and that remains these 2 volumes of loose-leaf commentary from, 40 or so expert practitioners and academics. And this covers not just company law, including the regulation of quoted companies, but also the whole of insolvency law as well. Now, the traditional strength of Gore-Browne has been its coverage of cases, not just cases in the United Kingdom, but cases from the whole of the common law world, where relevant, and of course, well, at least for the time being, cases in the European Court. It covers the law in England and Wales, and also all the variants north of the border in Scotland. Now, the biggest challenge for me, and indeed anyone dealing with company law, is the sheer expansion of the primary materials. Now, take for example Butterworth's Company Law Handbook. At the moment that has over 3,000 pages dealing with the legislation affecting companies. And it doesn't touch on the Financial Conduct Authority's relevant chapters, on the stock exchange rules, on the takeover code, etc. It is an enormous body of law which seems to grow year by year. Now, the key value of which I've been trying to maintain Gore-Browne for practitioners is to describe what the law is, what cases there have been, what has been decided, highlight issues which perhaps have not yet been decided, and also occasionally areas which perhaps require some reconsideration. The struggle and my main ambition is to keep it comprehensive but succinct. Now, you may not think that 2 volumes is that succinct, but I assure you it's a remarkable achievement given the amount of law and regulation it has to deal with.
Now, you mentioned obviously the challenges over time. A considerable challenge must have been the introduction of the Companies Act 2006. What impact did that have on the title and what you had to do to it as a result?
Well, there are about 80 chapters or so in the book, and it probably affected at least half the book. The first half of the book had to be completely rewritten because of the Companies Act 2006. The process was made more complicated because the Companies Act didn't come in as a big bang, it came in gradually. And also, a lot of the old law was left over. So one of the decisions I was having to make all the time is, how do we introduce the new law, and how do we keep the old law where it still remains, and in some cases still remains, relevant for practitioners? The other rather more practical issues in this is trying to check between 40 or so authors that we haven't left anything out, because all the ordering was changing, and that we weren't going in for lots of repetition because various different authors thought they had to cover areas. And finally, and this is always a problem where there are major changes, trying to check that all the cross-references remained relevant and accurate. So yes, it was a huge change. But it has to be said, only one of many. I mean, since then, we've had all the European changes dealing with the regulation of quoted companies. We've had a whole new set of insolvency rules. So it is only one, I'm afraid, of lots of changes which have, in effect, changed the whole content of the book over the time that I've been editor.
And when you were just clear of the Companies Act, or as it was just first ultimately coming into place, you then launched special releases in 2009. What impact do you think that's had on the user experience, and how is that? What value do you see in the special releases themselves?
Well, the special releases actually came out of the Companies Act 2006 because we started producing releases to show how the implementation was carrying on. Now, obviously, once the Act was fully enforced pretty well by 2009, then we have been using the special release, which comes out, that is the 2016 special release every year, to allow contributors and others to look at areas which they think have developed in the previous year of particular interest to practitioners. It allows them to go into greater detail than the main text would allow, or allows them to look at areas which perhaps are at the margins, or even perhaps just beyond the normal scope of Gore-Browne.
Looking to the future, we're facing Brexit, and the future is unclear for corporate lawyers as it is for the general public. As things are settled down in due course, what are the challenges for Gore-Browne, and what do you see as being the necessary changes that you're going to have to make?
Well, we don't know at the moment whether we're going to have a hard Brexit, a soft Brexit, a medium Brexit. It's all terribly unclear. In fact, in the short term, I'm not expecting Brexit to make a huge difference to company law regulation, other than in one potential area. The one area where we may have to make very quick adaptations is in the area of international insolvency, because how the rules apply to us depend on which system we belong to. Medium term, obviously there could be quite a lot of changes, but I'm not thinking that company law and regulation is at the top of the government's list of reforms, and so I suspect that is a medium rather than a short-term issue. Brexit actually is interesting because it also highlights one of the features of the special release. This 2017 edition includes work by myself and my colleague, Professor Gerard McCormack, looking at the medium-term effect of Brexit. What might change, what should change if we are released from European imprimatur on our laws in this area.
So Brexit is the future. Otherwise, in terms of the future, what do you see as what are different challenges that you think Gore-Browne has, and what are your plans?
Well, my predecessor, Tony Boyle, had to deal with going from a hard book over to looseleaf. Mm-hmm. As I've already said, the biggest challenge in a way is moving from looseleaf to digital. Mm. Now, I think there are huge opportunities here because with digital, we can link and incorporate the commentary that we have in Gore-Browne with primary materials, with cases, in a way that is user-friendly, that practitioners can get from one to another and look at the whole complicated area, which digital opens, which hard copy really makes very, very difficult. Now, here, I think LexisNexis's experience and, bluntly, resources allows this to happen in a way which probably couldn't have happened before. And that is, I think, the biggest challenge I have at the moment, is this move from loose leaf over to digital. I know, lawyers perhaps are conservative, I know myself that I would be loath to see the hard copy disappear. It's still much, much easier if you want to read in some detail and flick through from place to place following cross-references, hard copy than it is screen. Younger people, younger generation may find this easier than I do, but there are a lot of us lawyers that are going to be around for a long time, I expect, still wanting a hard copy version.
And Alistair, just in conclusion, what do you think is what is unique about Gore-Browne? What is its unique value as against the competition?
I think one of the key things that we have is an advisory board of practitioners, of leading practitioners, both barristers and solicitors, who, with me, review all the chapters in turn. It takes us a long time, there are an awful lot of chapters, to see that they are remaining relevant and dealing with the issues that practitioners really confront. It's terribly easy for us to indulge in almost historic debates about things which always used to interest us, but are actually no longer matters which practitioners are dealing with. And that, I think, has been the strength of Gore-Browne over the years, and I hope remains the strength, is that we remain relevant for practitioners in their day-to-day practice in the area of company law. Despite all these changes, I hope, and I certainly intend, to try and retain one of the big traditional virtues of Gore-Browne, and it's been in existence for over 150 years, and that is its presentation of what has been decided in cases. Keeping those cases relevant, making sure we've removed cases that are no longer relevant, guiding through what has been decided, what may yet still be decided, what may have been wrongly decided, and pointing to the problems of cases that we have in many cases existed for a very long time. That, I think, is where Gore-Browne has a strength over all the rival products that I know. The mix of practitioners and academics is important because we have to be conscious all the time that Gore-Browne is not a work that people are reading from front to back, or indeed reading a whole chapter. Practitioners are trying to find answers to specific questions. And the whole design of Gore-Browne is to ease that process, that a question arises and a practitioner can find, by going through case index or legislation trackers, to where in the Gore-Browne he can get an answer to that question. And we've got to keep that in mind all the time, because that is the principal virtue of the work.
Alistair, thank you very much indeed, very interesting. Thank you very much.
Thank you.